the meeting of the Inner Temple Historical Society. I am the chairman of the Inner Temple Historical Society. It is my great pleasure to be able to introduce this evening's speaker. It is rare, if not unique, for a historical society to become part of history itself. But in holding this lecture on the 100th anniversary of the call of the first woman to the Bar of England and Wales, we are, to some extent, becoming history, and the fact that we have before us such a distinguished audience of women judges and barristers will become a record for future generations. The audience here and online demonstrates the changes that have occurred in the last 100 years. Not yet enough, of course, but it demonstrates an inexorable tide, I'm pleased to say. A generation ago, in 1989, I wrote an article in the Inner Temple Yearbook about Ivy Williams. It was to note the 70th anniversary of the 1919 Act. At one point in that year, there were only 2 women benchers. Now there are over 100, many of whom have accepted the Treasurer's invitation to be here this evening. This evening's speaker is Dr. Frances Burton. As an undergraduate at St Anne's College, Oxford, she was introduced to Ivy Williams. And so, in a way, yet again, we are touching history. Dr. Burton went on to become a barrister, sadly not a member of this inn, but people make mistakes in their youth which should be forgiven. And in a long career in the law, she has been a tribunal judge and the author of numerous books for students and practitioners on family law, and a respected academic and innovator. I've had the pleasure of working with her on one of her ideas, which was the setting up of the Institute of Family Law Arbitrators, and we owe her much for that. In such a crowded career, she also found time to be a great supporter of the advancement of women in the profession, particularly through the work of the Association of Women Barristers. Therefore, it is singularly apt this evening that she is going to give us a talk on the first woman barrister, Ivy Williams. Frances, we look forward to what you're going to tell us.
Thank you, John. Well, I think we could put up the first picture, actually. The famous picture of Ivy. This lecture only uses a very few slides, and this famous picture of Ivy in her wig and gown, not wearing bands as we see, she's just wearing a soft white shirt, is the one that most people see in connection with articles about her. And I think it's also on the Inner Temple website as well. The next slide I want to show you, because it illustrates her great importance in Oxford as well as in the profession, is this one of the blue plaque that has been put up on her old home in St Edward Street, Oxford. She eventually got a DCL from Oxford and her other degrees as well, but she's still by far most famous for being the first woman to be called to the English bar, as well as to teach law at Oxford or indeed any university in the United Kingdom. And she was already teaching law by the time that she was called. The next slide I want to show you is the detail of her famous book. Now, this is just amazing. She wrote this book, The Sources of Law in the Swiss Civil Code, and it was published by Oxford University Press in 1923. But it's still available. And what's more, 99 years later, It's now in paperback, and you can get it for £16.99 on a standard order from Waterstones, who will get it from the publisher. And also, of course, you could even get it from Amazon with your Prime subscription and free postage. Get it tomorrow. Even. That is just amazing, a book of an academic nature, published at that distance in time, still available in paperback. It's really pretty good. The last slide I want to show you is one of Oxford in 1906, which was this one. 1906, the Oxford Society of Home Students, the predecessor of St Anne's College. As you can see, they are in the appropriate period dress, and I think that more than anything underlines her attachment to Oxford and the fact that she really was established in Oxford long before she managed to get Oxford degrees, because the rules were not changed until 1920. Those degrees mentioned on the blue plaque could actually be picked up. So that's all I've got by way of slides, I'm afraid. I'm somewhat influenced by Professor Michael Freeman, who always used to say, if you can't hold your audience with what you've got to say, go and find another profession, dear. So I think I could only give you other slides that probably wouldn't be very illustrative of Ivy's career, which is what I want to stick to. Because there is very shortly a new biography coming out by her cousin Bridget Wheeler, who I believe is here today. Oh, right, hello. Which takes a completely different tack. I've stuck to her influence in the law. And golly, she did have an influence, as you will see when I take you through what happened in the next 20 years after Ivy was called to the bar. It's unsurprising that she's such an enduring inspiration when one considers the 5 separate reasons for her remarkability as the first woman finally being called to the English bar on the 10th of May, 1922, and her contribution to establishing women as fully functioning members of the bar, even if she personally chose not to engage in a court practice. Although Bridget Wheeler kindly told me that when it came to her possibly being called to the bar, she was talking about how the women were coming and how the women were going to be in practice, but not her, it seems. I think she made the right decision by not going into a court practice, as perhaps you will see when I tell you what happened. Nowadays, she would clearly be the academic member of the advocacy team in some high-profile case in which her specialist legal expertise was relevant. Sadly, this practice of leading practicing barrister academics being associated with the bar as members of chambers for practical use in such cases had not really developed in her lifetime, but is now quite prevalent, especially in the higher courts. Surely Ivy would have wanted to bring in her specialist contribution in this way if she'd lived to 145 instead of to merely 88. So what are the reasons for her importance to this day, with her leading academic text even in paperback, as though it were one of this year's books of the year? Well, first, Ivy Williams' life was a long one, stretching not only from the latter part of the Victorian era and some way into the period of most ambitious commercial and social growth of the 19th century. She was thus born well before either of Queen Victoria's jubilees of 1890 and 1900, when people's daily experience, especially that of women, and whatever level of society, were completely different in that last quarter of the 19th century from their lifestyles in both 1922, when she got called after the social change of World War I, and 2022's theoretical gender equality 100 years later in the 21st century. But it was also a lifetime in which she and her parents and family would already have both seen and successfully managed great change, from her birth to parents within a long-standing rural Oxfordshire family background on both maternal and paternal sides, to her death as Dr. Ivy Williams, Honorary Fellow of an Oxford College, and living in academic North Oxford in 1966. That's to say, towards the end of the 1960s, that decade which famously marked that supposedly great World War II watershed of modern gender equality in the 20th century and beyond. I mean, at this stage, I guess all of us say, 52 years since the Equal Pay Act, 1970, and 12 since the Equality Act, 2010, and where are we now? Well, maybe we will all still have some contribution to make in that respect. In fact, it seems that she and her brother were both born at a time of significant change in their own family, as well as social contextual upheaval generally, which took their parents right away from Oxford for the 5 years 1875 to 1880, on what we would now call a career break, or maybe an adult gap year, and from their respective families' established pastoral Oxford origins and their developing commercial activity in the city of Oxford, in which her father, George Swithin Williams, had set up a high street office, both as an Oxford solicitor and proactive small businessman. And owing to their parents taking this period of time out, resulting in both her brother and she herself being born respectively in Ryde in the Isle of Wight and Newton Abbot, a Devon market town equally far from her family's Oxfordshire agricultural origins. This shift of perspective was quite a sea change, albeit a fairly usual one in that period of the 19th century, in which many families were definitely moving with the times. So the remainder of her achievements are almost just a further development waiting to happen. So we're not really at all surprised by her story. So that's one reason. Secondly, even before 1922, Ivy's was to an extent a tirelessly crusading life, in which, as Dr. Williams, also the first woman law don, either at Oxford or in any other university in the United Kingdom, she had long before 1922 already lived through and successfully personally managed the life she wanted, which she did by finding a route over all the hurdles in the way of even women's legal, academic, never mind professional advancement. Obstacles which strictly persisted when she was a girl, of which she clearly strived to take no notice and allowed no diversion from her goals. Indeed, her confident surmounting of all of that, long before 1922, no doubt laid the foundations for the 20th century lifestyle women barristers could later expect on equal terms of membership of the legal profession. Not able to matriculate or graduate from Oxford University, having followed the jurisprudence course at the Oxford Society for Home Students, she simply took the London University's external degree examination, which was in effect until well into the 21st century, largely supervised by the group of London University colleges, which issued material in the form of syllabuses, reading lists, regulations, past exam papers, and advice, but no tuition as such. This was prepared on her, which was widely used by civil servants overseas who were unable to attend in person at an English university, as well as to hold on to their jobs while they were away governing the empire. Ivy thus graduated from London with an LLB in 1901, 1903, and then persisted in her ultimate aim of pressing to collect her Oxford degrees, a BA in jurisprudence, an MA, and a BCL, which was only eventually permitted by Oxford University in 1920, when the rules were changed. In 1923, Oxford then gave her a DCL for her learned work on the sources of law in the Swiss Code. That's the one that's now in paperback, as though it's the latest bestseller of the year. Still available from the publisher's Gale and the usual bookshops. And I've put all the details of how to get it on the slide, so you can if you want to. At the same time, she endowed 2 Oxford Law Scholarships, one for women only, and both in memory of her brother Winter, 2 years older than her, but who, as soon as being a man he had qualified as a barrister, had been able to be called, but then soon died young at the age of only 27, leaving Ivy to persist in her ambitions alone. Indeed, because even the first woman's call in 1922 was by no means the end of the story, Ivy's perseverance up to that date inspired important developments in the history of women in the law generally and at the bar in particular, especially in the 2 decades of the later 1920s and 30s, those crucial 2 decades after the first call, without which women lawyers would probably not have been at all well placed to take advantage of the opportunities they eventually found becoming available to them in 1939 to 45, so as to advance their progress in the profession during World War II. This, of course, was when, while the men were at the war, someone had to hold the fort in their absence in the law, and which unsurprisingly resulted in women being available and competent in those wartime years between 1939 and 45 to take on work in the law that might otherwise have had to be left undone in the absence of men, unless women could be roped in, as also happened in all the other walks of life, where these gaps were similarly filled, if women could be found to fill them. In other words, World War II was not only about land girls and the present Queen qualifying as a young adult princess ATS driver and motor technician, as we are now being reminded at the approach of the Platinum Jubilee, but advancement of women in other fields too. Examining that later period, together with the years up to when Helena Normanton and Rose Heilbrunn then obtained silk as KCs in 1949, only 28 years on from that first 1922 call, and only another 7 till Rose Heilbrunn became Recorder of Burnley in 1956, which was then the very first female such appointment, and an important one, as that was and is still the first rung on the ladder towards permanent judicial posts. So it's quite likely that but for the solid background of women being called between 1922 and 1939, and their sterling record in 1939-45, such closely post-World War II advances might never have happened. Because although the 1919 Act immediately allowed female law students to join the Inns and the Law Society, and those professional bodies and everyone to get used to the change, the women students still had to qualify. So that while the legislation also allowed 3,700 new lay magistrates to be appointed immediately after the passage of the 1919 Act, and thereafter the magistracy relied heavily on female JPs, women coming into practice and in the judiciary took much longer to establish. Thirdly, her importance is underlined by the fact that in the 1920s and 30s, this followed a very rocky period between the unsuccessful challenge to the Law Society in 1913 by the aspirant solicitor Gwyneth Bebb, when the court hearing the case famously decided women were not persons and therefore had no right to admission to the profession, and Lord Buckmaster's 1919 Professional Enabling Act, on the successful enactment of which it was indeed the case that women could suddenly, after all, be admitted as law students to the Inns of Court and the Law Society. That was just opening the gate. Full qualification as men, that is, for call to the bar, fulfilling their Inn membership obligations, passing the Bar or Law Society examinations, as there were then no compulsory pupilages, women barristers could then finally make use of their newly called status or qualification as a solicitor or barrister, either in independent practice or in one of the then so-called non-practicing roles at the bar. But this didn't mean that noticeable change came quickly, because apart from the time lag between successful admission applications and reaching call at least 2 years later, this was strange new ground for women to familiarize themselves with, and also for everybody else to get used to the idea of women lawyers. Nor was this instantly set automatically to produce an inrush of newly qualified women, either barristers or solicitors, since apart from time having to be taken to achieve readiness for call or entry onto the roll of solicitors, these pioneer women had decisions to make as to how to go about their newly possible careers. Moreover, the period had been a slow one, of virtually static and struggling hope that Lord Buckmaster would in fact get the 1919 Act through the legislative process without much universal expectation that it would actually happen. So after 2022, the new entrants to the profession did indeed only emerge slowly into practice or non-practicing roles up to the end of the 1920s. We've got quite a bit of research on what happened then. However, in Ivy Williams' case, following her call in 1922, that entry into the qualified profession as a new member of the bar was in fact instantly achieved by her going straight back to the Oxford Society of Home Students, where she remained in her academic appointment teaching law, one of the principal employments for non-practicing barristers, especially women, and where she remained until her retirement in 1949. Although from around 1930, there was a noticeable increase in middle-class women taking the plunge into practice. That is mostly from families with some private income available to fund the risks of incurring more expenses than fee earnings. One of these, identified by Patrick Polden, was Dorothy Lever of Middle Temple, who had two brothers already in the law and had married a solicitor, had good connections in the north, where it perceived as often easier to establish a practice. And then she had a lifelong career as a magistrate and in other fairly high-profile research and writing contexts. In these circumstances, perhaps World War II has to be seen as a benefit to the development of an increasing corpus of women at the bar, as whereas it's clear that men's practices were adversely affected by the war when they came back to the bar in the immediate post-World War II years of 1945 to 1960, which was also a fairly gloomy time of rationing to 1954, together with a certain parsimony in an era of very high taxation. However, there was some evidence that women barristers actually benefited from the men's absence in wartime. Indeed, these favourable conditions for women at the bar continued to some extent because of the provision of legal aid by the post-war government in 1949, until that later came to be referred to as this blank cheque and was restricted by successive Conservative governments. Although, unfortunately, despite a positive period at that time, it's unfortunately clear from Lady Justice Nicola Davis's recent address at the relaunch of the 2011 Inns of Court Alliance for Women that it is, as she said, dispiriting that in the case of those in independent practice in chambers at the bar now, gender equality still has a considerable way to go, 100 years after the bar was opened to women. Indeed, it looks at present as if gender equality might currently have reached a plateau, where there are now quite a few successful women barristers and women judges in the higher courts, a lot of codes and rules and regulations. However, at the other, more basic end of independent practice in chambers, ethnic minority women are apparently earning only 41% of the income of white male barristers. And we know from frequent media comment that some criminal practitioners, particularly women, are not earning enough at the criminal bar to make a profit after meeting the expenses of their practices. This is why they keep telling the press they're going to go on strike. Fourthly, therefore, since Ivy did not, as she might have done, rush straight off into practice in court, which some still apparently think to be the only suitable prime activity for barristers, but went directly back to her already prestigious university academic appointment. Her achievement in obtaining court of the bar immediately this was possible for a woman must next be given credit for the important benefit to her successors of thus establishing the value of merely actually qualifying as a barrister, whether male or female, and even without an intention to practice as an advocate in court, since this finally achieved step did immediately enable women to work in other important law-related but more family-friendly contexts outside actual practice in the court, which it is clear to many of them they were yearning to do at that time in 1922, and this also was the case in other walks of life because of the social change created by World War I, and not only in the law as such. I think this was in particular also important for women because as the skills acquired on the various iterations of bar qualifying courses have often claimed, bar education is well fitted to provide a foundation for more than practice as a legal practitioner. Patrick Polden's research, establishing the very varied roles taken up by women called between 1922 and 1939, has indicated the wide range of activities available to barristers at that period, and indeed many of which are continuing today, and which are in particular attractive to women seeking a more family-friendly occupation than in the context of advocacy in a court practice. And these have included women barristers taking up appointments as company and legal secretaries, court clerks, civil servants, legal executives, local government employees, law reporters, editors in publishing houses, employees of solicitors' practices, and more, all of which were promoted in Glanville Williams' 1945 first edition of his famous book, Learning the Law, in which he tried to encourage law students to look for other ways of using their legal qualifications. Further, Polden's painstaking survey of calls to the bar of women from 1922 to 1939, pre-World War II, made it clear that qualifying for the bar and establishing a practice might still appeal as an occupation for women from professional families who were able to call on even a small private income to supplement their earnings and their management of the daunting expenses of establishing a practice at the time when today's extensive scholarships were not in place, especially if they were able also to obtain some income from university law teaching, such as Ivy had set a pathway towards. A number of such women still came from the north, where establishing a practice was often thought to be easier for men as well as women, and where many members of Eastern European families, which had escaped to northeastern and northwestern circuits from oppression in Europe, for example, including the northwestern cities where Rose Heilbrunn built a heavyweight criminal practice that enabled her to be appointed to the recordership of Burnley. However, as time went on, women came to be in practice in London and the south, as well as the north, which meant that such practices could also be supported by part-time academic work in London and Oxbridge, including at the Inns of Court School of Law, which in the more immediate post-World War II years recruited the part-time services of some of the most distinguished academics rather than using entirely full-time employed staff, as later came to be the case. Moreover, this entirely appropriate law-related employment for newly qualified practicing barristers could be engaged in at weekends, even by practicing barristers working flat out in court all week. And this clearly included academic law teaching, even in less prestigious colleges than Ivy's Law School at St Anne's College, Oxford, which was by then the new persona of the Oxford Society for Home Students, when it became a full college of Oxford University from 1952. A number of women built substantial practices in this way in those post-World War II years. Thus, following Ivy's lead in returning to her Oxford post after call in 1922, many young barristers of both sexes taught at universities at weekends while devoting their weekdays to practice. And women barristers who obtained a tenancy in chambers often also sought hourly paid teaching sessions, delivering to law students the rounded academic tuition that is made possible when a student's grasp of black-letter law is holistically informed while they are studying for their law degrees by the tutor's familiarity with the law's practical context in what used to be formally recognized and valued as the academic stage of legal education, that is, learning in depth the theory and principles of the law, on which the late Professor Peter Birks, formerly Regius Professor of Civil Law at Oxford, had strong views on the importance of this thorough learning supplied by the 3-year Oxford University tutorial system law degree, often referring to the graduate diploma in law, the fast-track conversion course for non-law graduates, as suitable only for parrots. Indeed, it's often been said that the academic who has no knowledge of the practical application of the law is a danger to students, and this indeed became even more true when the professional qualifying examinations became devolved to the universities by both Bar and Law Society in the 1990s. Professor Claire McGinn's 1998 title, The Woman Lawyer, indeed makes clear the substantial practical contribution of women lawyers to academic law teaching, often still allied, unfortunately, with lack of promotion on equal terms with men, which is another thing that perhaps we should be turning our attention to. So I think Ivy's contribution to women's ability to make use of their call to the bar has been rather spectacular. And that's the fifth reason why I think she's really quite remarkable in being the first woman to be called to the bar as soon as it was possible to be so. And this also highlighted the importance of Oxford's role in late 19th century women's education, which is recorded on the law faculty website. Although despite the fact that she studied law at a college at Oxford with a prominent feminist profile, pre-1922 circumstances restricted women's access to Oxbridge degrees, and that dictated that her first degree was actually from London and not from Oxford. That part of the Oxford women's education story had begun in 1876, the year before Ivy was born, when a group headed by the wife of the Dean of Christ Church founded both the Oxford Society of Home Students and the nearby Wychwood School for Girls, both designed primarily for the blue-stocking daughters of dons and similarly educated persons of substance who, already living in Oxford, would have liked to be able to study to a tertiary education standard at their local university. Another example of change in the late 19th century. And indeed, they could study in such a manner, even though they could not be examined or formally qualified until 1920. Thus, there is a clear case for our not being led astray by the fact that Ivy's birth took place in Devon, which seems always to have been a complete red herring in her story, having no real influence on her life. She was clearly always an Oxford person, as demonstrated by her lifelong attachment to both university and city in all the years she lived there, when she taught at the Oxford Society for Home Students and then chose to retire to North Oxford, having also founded 2 law scholarships, one for women only, in memory of her brother Winter. Indeed, he had no more connection with the Isle of Wight than she did with the West Country, since her parents' antecedents on both sides were from solidly Oxfordshire rural backgrounds, originally around Witney and Summertown, once a completely distinct village from Oxford, only later swallowed by Oxford City. And her father, George St. Stephen Williams, who was born in Cote near Witney, as were many of her parents' ascendants for several generations, had been admitted and practicing as a solicitor in Oxford since the 1850s. Indeed, the birth of Ivy's elder brother, Winter Williams, in September 1875, at Wright on the Isle of Wight, marked the beginning of the 5-year absence of Winter's and Ivy's parents from Oxford, as already mentioned, which might have had something to do with the fact that their father, George, had eloped from their house in Summertown with the children's mother, Emma Ewers, who'd previously been the family's servant. And she too was from a similar rural Oxfordshire background as his own, besides at the time of the elopement, still under 21, so needing parental consent to be married at all. The couple was, however, back in Oxford by early 1880, then with their 2 children, and in the meantime, the children's paternal grandfather, the Oxford hatter, tailor, clothier, linen draper, and robe maker Aidan Williams, also born in Cote, had died in 1876. And although Ivy's father, Aidan's son, George St. Swithin Williams, was a solicitor, the executor of Aidan's estate were Aidan's son-in-law and a Summertown neighbour, John Lindsay, suggesting that there might have been a family estrangement over George's marriage, which made a period away desirable. If indeed there had ever been a formal marriage, as no record of one has apparently been found. Nevertheless, as there are also suggestions that the couple was also in Scotland at some stage during the 5 years away, there was probably a simple explanation for that, as a record might not have been necessary, since owing to the Scottish custom of recognising their system of marriage by cohabitation and repute, a ceremony and the attendant age restrictions for the wife could have been circumvented, since proof of a more formal marriage would only have been needed in Scotland if George had died during that period, since that Scottish law was really designed as a feature of probate rather than matrimony. And as George was 20 years older than Emma, he might well have been concerned to ensure provision for her in the event of his early unexpected death. Good husband, obviously. In any case, from 1880, George St. Swithin Williams was again working in Oxford, initially from his father's old shop at 136 High Street, and then at 2 addresses in King Edward Street, at the second of which, number 12, a local builder and architect who'd had his business address at George's father's old office carried out alterations, whereby George was able significantly to develop his solicitor's practice there, which then included banking services and the provision of loans from his Oxon and Berks Bank, which he founded at the same address, so that he was at that stage known as a solicitor and banker. Obviously, in some comfortable circumstances, the family lived upstairs and they had 2 servants. Ivy was then able to be educated at home with her brother, and instead of going to school, studied the same curriculum as he did, which it seems even included Russian, which explains her fluency in several European languages, including those needed to prepare and write her text on the Swiss Constitution, as well as Latin. In 1891, Jackson's Oxford Journal, it was recorded she'd obtained a distinction in 3 subjects in the Oxford and Cambridge Schools examination, in German, French, and additional mathematics. In 1892, it was also recorded that she'd passed English grammar, Latin, German, French, arithmetic, algebra, Euclid, geography, and English history, with distinction in Latin, where she was second of the girls, German with the country's top mark, and French, where she was 12th. In 1893, when she was still only 16 and 10 months, her results were so good that she obtained a certificate of exemption from the university's first examination for women, which came with a statement to entrants that the university would allow women to take the examinations, but that they would get no degree nor be allowed to matriculate. She then went on from the age of 19 to read jurisprudence at the Oxford Society for Home Students, while still living with her family at 12 King Edward Street, and duly passing the university's examinations, but of course not receiving the degrees she won. BA in 1901, BCL in 1903, until 1920. Nevertheless, of course, there was still this option of London University, now known as the University of London International Programme and still going, by which a student could study remotely, and many still do, just as at the Oxford Society of Home Students in that pre-1920 period. And this was a graduation route favoured by a lot of people, even into the 21st century. Meanwhile, Ivy's brother William, being a man, was able to read jurisprudence in Oxford at Corpus Christi College, although he too took those London University examinations, which were regarded as a demanding and prestigious qualification. And at the time of the 1901 census, he was still living with the family at number 12, although at the age of 25, he was by then a young barrister, having also become a member of Cowley Parish Council when he was at the time about to occupy a farm at Cowley, obviously returning to his family's former agricultural tradition. However, he did then very soon die prematurely at the age of only 27 in 1903, and following his funeral at St Mary the Virgin Church in Oxford, he was buried in Holywell Cemetery. But sadly, his father George then died in 1904, leaving Ivy's mother Emma a young widow, whereupon she and Ivy moved to Cowley as well, until 1920, when they again moved to Staverton Road in North Oxford, which was somewhat more practical for the later stages of Ivy's life after she retired from teaching law at the Oxford Society for Home Students in 1945 and was made an honorary fellow in 1956, following the newly named St Anne's College, having become a full college of the university. In later life, sadly, her sight failed, which must have been a great tragedy for her in view of her intellectual interests. And she wrote a Braille primer to help people like her who were losing their sight. However, by this time, her fame was long established and well recorded and appreciated, not only in Oxford, but at the English bar, and wherever feminists celebrate women lawyers' contribution to and participation in the law. So I think it's rather good that we're celebrating her call today. Thanks.
Well, thank you very much, Francis, for that tour through the life of somebody of such significance to the profession, and particularly, of course, to women in the profession. Before we move on to questions, you were telling me, as we came in, that you'd had the opportunity through the archivist of the Inner Temple to look at the papers we had here. It's a file I looked at myself back in '89 when I wrote that article, about how this inn, the Inner Temple, viewed women coming to the bar. There was, to some extent, then, as I hope now, we were slightly in advance of the other inns.
Yes,
what did you find?
As proactive as Ivy, definitely. It's probably why she chose Inner Temple.
Now, are there any questions? There's a roving microphone, which there. I've got the online questions here, but I need a moment or two to open them, I'm afraid.
Oh.
Hello.
Kate. Oh, Victoria. I'm so sorry, I didn't see her.
Should be on. It's on. First question is, how do you turn the microphone on?
It's on. It's on.
And it seems to be on. The question that crossed my mind was, what was the nature of the examinations that she was required to take when she was called to the bar? What was the process she had to go through to get there? And how does it differ from what happens today?
The Inns of Court School of Law had been setting examinations for call to the bar since 1846. And I think they were of a more academic rather than practical nature. They hadn't changed by much until the bar vocational course was created in 1979. So they were very similar to taking academic examinations at university. And in fact, if you had done a university degree on the same subjects, and it was covering a sufficiently similar part of the syllabus for the bar examination, you could have exemption from part 1. You still had to take part 2, which was of a more practical nature, but included a bit of drafting and some knowledge of procedure and evidence, but still not as practical as in the subsequent bar vocational course. In fact, I think I might still have some very old bar examination papers, if you're sufficiently interested. I think most people thankfully threw theirs away,
some of us still
but
have
I've always squirreled my mementos in various places. And so we're only now getting around to chucking some of them out.
Apart from Swiss law, what did she teach? What were her specialist subjects when she was an academic
Well,
at
she
Oxford?
would have, I imagine, have taught mostly international law because that was her interest.
Thank you.
Just reminding myself of an article that Heather Hallett, whether Heather's here, Master Hallett wrote in 2011 when she chose Ivy Williams as her legal hero. And she said this, she said, "She is someone who never practiced as a lawyer, but who opened the door for other women to do so and for women to expand their horizons generally. She did not chain herself to railings or throw herself under the king's horse. She patiently and persistently knocked at the door of the bar, a male bastion, if there ever was one." And I wonder whether you, Dr. Burton, had any comparative thoughts on the efficacy and the achievement of Dr. Ivy Williams in promoting women in that rather quieter way than the very obvious activities of, for example, the suffragettes.
Well, the plain fact is she didn't go into practice. She stayed as an academic. But I don't actually see anything wrong in that because obviously she had a choice to make. And many women didn't go straight into practice. They engaged in those activities which later came to be known as non-practicing, but which might now be called employed practice, including such roles as court clerks. And we have a lot of court clerks to this day who are actually barristers and have not practiced.
Thank you. Before we move on to the next question, which is here, please, just want to note that I'm sure Ivy Williams would be utterly thrilled by the fact that the last three questions came from Lady Justices of Appeal.
I'm Ivy's cousin, twice removed, and I want to thank...
Yes, we're very glad to hear from you, Bridget.
Yeah, I want to thank you,
We're
Dr.
going
Burton.
to read your book, aren't we?
I have got the flyer with me. It can also be bought on Apple Books. But I wanted to just add a couple of things to what's been discussed this evening. And the first is about the exam she took. They were perhaps a bit surprising that what she took bar finals in at the time were constitutional law, legal history and conveyancing, in which she got a first, which is unsurprising as she'd been working as a conveyancing solicitor during the war. So I have no information on the practical drafting apart from in the context of conveyancing, but that is what there is a record of. But I think it's also important in the context of her importance in advancing women generally in the legal profession to remember that not only was she the first woman barrister, not only was she the first woman tutor, but she did public work as well. She was Britain's representative to the Hague Conference on the unification of international law in 1930. She got there by being a safe pair of hands because she wasn't a militant suffragette. She was somebody who would argue, but she wouldn't disobey the law. And she addressed that conference in French. She was also a translator outside the law. She translated the work of Garshin from Russian as the first thing she did as an Oxford tutor. And then the final thing she did that I think is arguably an indication that she was a quasi-judicial appointee was in 1932 she was appointed as the woman on the advisory committee on the deportation of aliens, which was intended to be an advisory committee to the Home Secretary at the time, but turned out to be basically an appeals tribunal, and a rather radical one at that. They had about 22 cases of illegal immigrants, as we would perhaps think of them today, refer to them, and they rejected the Home Secretary's request for deportation in at least a third of them. So I hope that's of interest.
Thank you. I have a question online from Linda Goldman. Linda asks, how big a hurdle was it for a woman to obtain pupillage, presumably in the early years of the time when they could first be qualified?
Well, pupillage was entirely voluntary until it became compulsory.
When was that? I don't know.
1980s?
Oh, I see. No, I think not.
Sorry?
Well, certainly I can say with some considerable confidence that it was compulsory in 1970.
Instead of pupillage, you could do an extra course at the Inns of Court School of Law for non-practicing barristers.
Oh, for non-practicing barristers? Oh, right.
But it wasn't until employed practice was regarded as genuine practice that women in employment were regarded as actually practicing. And so we have to look much later than that, into the 1990s and beyond, for all the employed roles to be regarded as practicing as much as independent practice in chambers. And that was when the employment bar got a seat on the Bar Council after the Alexander report.
The gentleman in the back row here has a question, please. They'll bring you a microphone. Wait for the microphone, please, because we need to record it on the online, and it doesn't get there otherwise.
Yes, also the acoustics are not so good from far down in the church.
Good evening, sir. Mr. Fenton used to be my lecturer at the University of Buckingham. So the question I wanted to ask before has been answered by you already, so it's okay now.
Oh, right. Very well. Thank you very much. Are there any other questions? No, well then, I think all it... Oh, hold on, I'm so sorry. From counsel. As I have the advantage of being online, the bar has prohibited pupils from taking briefs during the first 6 months only from 1965. The completion of a period of 12 months pupillage was with a qualified pupil master has been compulsory as a requirement since 1959. And then J.D. Burton writes as follows, while it is clear in the wake of women like Ivy that there's a lot of progress towards equality, you also acknowledge that women seem to have reached a plateau, with equality still beyond our reach. What catalyst needs to occur in order for genuine equality to be possible?
In the absence of a crystal ball, I think that question is extremely difficult to answer. And perhaps Lady Justice Nicola Davis has some view on that, since she's already said it's not really likely to happen very soon. Or at least that was what the Times reported when they reported the recent evening of the relaunch of the Inns of Court women's organisation.
Yes.
Well, I wasn't quite expecting that. As it happens, we, that is the co-conveners of the Inns of Court Alliance for Women, had a meeting immediately before joining the lecture this evening. And you will be unsurprised to hear that we are talking about future events for the Alliance and what we can do to further its causes, and in particular, support and encourage women. And it seemed to us, and forgive me if this is blindingly obvious to all who are listening this evening, that there are three issues: the early years, retention, and then career progression. And in fact, they all lead one into another. As you may know, we recently held an event directed at senior clerks and heads of chambers, which is looking very much at those issues, but in particular at the fair and transparent allocation of work for women. But it seemed to us we need to look further, and a really acute problem is that of retention, because it is not only the fact that women are leaving the bar. What it ultimately means is that there is a smaller pool available for women to be appointed to the judiciary. They're coming through within the tribunals, the district bench and the circuit bench, but we have still to see it within the senior judiciary, and that is a matter of considerable concern. So in answer to your question, no, I don't have a crystal ball either, but what I can say on behalf of the Alliance is that we are focusing upon the issues of early years, retention and career progression, and we will be doing what we constructively can to take these matters forward, because ultimately we want to see far better representation within the senior judiciary, and the Supreme Court really does deserve more than one woman, however good Lady Rose is.
Thank you very much. Lady Justice Nicola Davis was not on camera, and so I just record her presence and our thanks to her for those observations. Is there one more? Yes? And then I think it will be time to move to the round of the church.
Sorry, I was just wondering whether you would have any view, actually either of you, about what Ivy would think were she here today, notwithstanding the eminence and achievements of many of the female lawyers here, as to the progress that had been made following her first great step.
Well, I think Ivy was a child of her time, anxious to advance women beyond their previous restricted domestic roles. And certainly, anecdotally, there's quite a lot of evidence of women wanting to get jobs after the end of World War I, wanting, for example, to go into banking, and finding that there was resistance from their families on the basis that that would be taking a job away from a girl who might need it, rather than in the case of women from better endowed families not needing it at all, except for their own personal advancement. But I think Ivy thought about the advancement of women generally, as well as what she wanted to do. But that's a fairly normal attitude for an academic lawyer entrusted with teaching students to take. I'm sure if there were restrictions now, somebody like her would have wanted to go into the profession. I mean, look at the problems that have been experienced by women under the Taliban in Afghanistan. The Association of Women Barristers did try to help them the last time the Taliban was in charge, because that was creating a big gap in the middle of the legal profession there, where women were not being allowed to be educated. And it was extremely difficult for us to help them. because we couldn't really send them any correspondence courses because it didn't have any infrastructure in Afghanistan at the time. We couldn't send them any online courses because the electricity supply was so unreliable. And they got out of all that, got rid of the Taliban once, and now they've got them back again. And so be interesting to see what happens this time, because I think there must still be women who want to have education, and in particular professional education.
Thank you for also inviting me, but I'm by and large going to defer to the speaker this evening. The only thing I would say is that
I didn't mean you, I meant his cousin twice removed.
Oh, I see. Oh, that's even better. I could really get out of answering the question. Yes, thank you very much. Do you have any view as a family member?
I do have a bit of a view. Ivy was disappointed after she was appointed as tutor at how little work she had. That is why she took a couple of years to go to London and to study for the bar properly, if you like, did a bit of distance teaching herself, was able to sit on these committees. She was disappointed that women didn't come to her to be taught. And towards the end of her life, I think she did suffer from depression. And not only was it because her sight was failing, but because I don't think she felt she'd made a significant impact. If she was here today, seeing all these eminent ladies, I think her heart would be lifted. But I still think, being a realist, she would look perhaps not as far as Afghanistan, but to the stories we hear of sexual misconduct at the bar, at women failing to be retained within the profession, and she would not be surprised.
Well, thank you very much. I'm very grateful to you for that additional contribution, and look forward to reading your book with real interest. Thank you. Well, now, ladies and gentlemen, I should finally say two things. That this talk and this evening's events have been recorded and will be available online. If anybody wants to look at those, and I've got one or two, indeed more than one or two comments of thanks to Francis on the chat in front of me, and inquiries as to whether the talk was in fact recorded. So it will be there for anybody. The next thing I have to say is that at a moment I'm going to invite everybody to go down to the round of the church, which will be well equipped with glasses of wine and other drinks for those who do not want to partake in wine. And finally, with great pleasure, to thank Frances for her extremely informative talk this evening and all that she has done in her lifetime to advance the cause of women in the legal profession. Frances, thank you so much. We all owe you a great debt.
Pleasure.
I'm not allowed to hold on to this. I'd like to.